Hello again, I'm attorney Vince Davis. Today, we are diving into the powerful new protections taking effect for California tenants in 2025 and 2026. California is leading the nation with aggressive new laws designed to stop wrongful evictions and landlord harassment once and for all. The cornerstone of these changes is Senate Bill 567, which significantly tightens the rules on no-fault evictions. If a landlord claims they or a relative are moving in, they must now move in within 90 days and stay for at least a full year. They also have to identify the specific relative in the notice. If they fail to do this, they could be liable for major damages. For years, the substantial remodel was used as a loophole to push tenants out. Those days are over. Landlords can no longer evict for remodeling without first obtaining all necessary government permits and providing copies to the tenant. The work must be significant enough that you cannot live there for more than 30 days. Minor cosmetic upgrades no longer qualify. If a landlord violates these SB 567 rules, they can be sued for treble damages, that is, triple your actual financial losses. You may also be entitled to punitive damages and having the landlord pay your attorney's fees if you win your case. Now, let's look at habitability. California is expanding what it means to have a livable home to prevent constructive evictions. Starting in 2026, a working stove and refrigerator are considered essential services. Landlords must provide and maintain them. If an appliance breaks, the landlord has 30 days to fix it. If they don't, it's a serious habitability violation. This can give you a strong affirmative defense if you are ever facing an eviction for non-payment of rent. Effective in 2026, landlords must also halt rent if a natural disaster makes your unit uninhabitable until repairs are done. The law also requires them to remove debris quickly. You shouldn't be paying rent for a home you can't safely access. One of the biggest procedural changes involves the unlawful detainer summons. Tenants finally have more time to react. Starting in 2025, you now have 10 court days to respond to an eviction summons instead of just 5. If you are served by mail, you may even get an additional 5 days. This extra time is crucial for finding an attorney. Missing a deadline often meant losing your case automatically. This law helps ensure every tenant gets their day in court. There is also a new defense for seniors. If your Social Security benefits are delayed by the government, you can delay an eviction. Once your benefits resume, you have 14 days to pay the back rent. This protects our most vulnerable neighbors. Landlords are also facing new rules on application fees. As of 2025, they can only charge a fee if a unit is truly available. They must process applications in the order received and refund any fees for applicants they do not screen. No more ghost listings. Additionally, landlords are now banned from charging you a fee just for serving an eviction or termination notice. They also cannot charge extra fees for paying your rent or your security deposit by a traditional paper check. Security deposit disputes are the #1 issue between tenants and landlords. New laws require photographic proof. Starting in July 2025, landlords must take before photos of the unit at the beginning of every new tenancy. Even sooner, by April 2025, they must take after photos within a reasonable time of move-out, but before any cleaning begins. If they don't have these photos, they lose the right to keep any part of your deposit for damages or cleaning. Period. If a landlord wrongfully keeps your deposit, you can sue for up to 3 times the amount of that deposit in damages. There's also good news for your credit. Large landlords must now offer you the option to report your on-time rent payments. They can only charge a maximum of $10 a month for this service. It's a great way to build your financial future while renting. California has also banned landlords from using common pricing algorithms to collude on rent hikes. Your rent must be fairly set. Remember, if you're a victim of landlord harassment, you can sue for statutory penalties of up to $2,000 per violation. These new laws are designed to professionalize landlording and give you, the tenant, a robust shield against intimidation. To recap, we have tighter move-in rules, required appliances, more time to respond to court, and mandatory deposit photos. Understanding these specific bills gives you the upper hand when dealing with a difficult landlord. Knowledge is your best defense. If you believe your rights have been violated or you're facing a wrongful eviction, don't wait until it's too late to get help. Our team is dedicated to protecting California tenants and ensuring the law works for you, not against you. Call us at 888-888-6582. We look forward to hearing from you and protecting your rights.